that we'll start at 10:45 because of the fire alarm, just in case some people were still out. The way you all seated so comfortably, it looks like you were not affected. Were you? Oh, okay. Yeah, so, okay. But anyway, you know what was happening. Yeah, so I thought people were outside, so I'm giving people a few more minutes to come up. So what we'll do is we'll have this class and reschedule, right? So in other words, you get more time. Because in effect, we've lost close to an hour with your break time included. So, so we'll have it, and I will put on an additional class so that we go over things again, right? I hope that's clear, because obviously the fire alarm started at about 10 and it derailed us. So if you just give it a few more minutes to allow some people to come, just in case. The timetable, people will check your schedule to find a block that works for everybody. Okay, I think we can start now. I did send two messages to you. I don't think they've arrived. One basically saying, "Hey, there's a fire alarm," and the other one saying, "Hey, fire alarm is over." Obviously, and so if you see them, please ignore. Um, so. So today we're looking, now that we know what the organs of the company are, we're looking at the law on the control of management through the board. Right, so remember, it's about controlling management. So you remember we talked about the rise of managerialism, and we need to cut them down to size, right? Because managers are the ones who drive the company forward, who basically take day-to-day decisions, and so the question is, how do we control them? How do we watch them? We do this through the board. So that's the role of the board, to essentially monitor management, to advise management, to provide strategic advice, etc., etc., etc. Right? So, so that's essentially how that works. Now, company law, obviously, if I was to give you a reference to a company law textbook, it would simply just talk about duties of directors. And that's why I deliberately did not give you any reference to any sort of company law textbook. It will take you through all the duties of directors. But that's not what we want. What we want to do is to see how the board, which we identified as an organ, how that board is rendered effective. Effective to what end? Effective to the end, to the goal of monitoring management. So when you see the Code on Corporate Governance talking about board effectiveness, that is what it has in mind. You understand it? It's board effectiveness. Effectiveness is not effectiveness in a vacuum. It is simply effectiveness to ensure that the board is able to constrain managers. And what I'll do here is just pull out a document which I think would be useful for you to look at. Just So this document on the FRC, if you remember, I did mention this document at the beginning, and I give you a link to it at the beginning of the course on the guidance on board effectiveness. So essentially, when you read the Code on Corporate Governance, because remember the code is just a framework code, you then need to look at the guidance issued by the FRC on how to implement this code, right? And you see here that, you just look at the table of contents. The document is essentially saying that the board should provide leadership. The board should be effective. So we, and company law doesn't ask this question. This is the point. Company law just assumes that, okay, we'll have a board. Company law does not tell us how to choose board directors. Company law says nothing about diversity. Maybe now we have, the statement on gender diversity. Right? But generally speaking, company law doesn't say anything about this. But the Code on Corporate Governance deals with this, and then the guidance on board effectiveness fleshes this out. So So you notice here it talks about the division of responsibilities. Company law doesn't tell us about the role of the chair, right? The role of the chairman. As far as company law is concerned, everybody's a director. The company law says nothing about independent directors, independent non-executive directors. Company law says nothing about that. So here we see this. It talks about division of responsibilities, the board committees. Again, company law is completely silent on board committees, right? Company law is just more concerned with the constitutive rules necessary to get the act, the whole process running. And what are those constitutive rules? The company, separate legal personality, limited liability, a board of directors. Then it stops there. And then it says, well, if the directors breach their duties, right, then they'll be penalized. That's what company law says. Then, so company law students then read directors' duties in a textbook. So we're looking at board committees, the role of the senior independent director, right? So think about the senior independent director as a counterbalance to the CEO, right? Because the CEO basically sort of runs things, but here we now have independent directors, and we now want this guy to be a senior independent director who basically will take soundings from staff, right? So if there's going to be whistleblowing, you want to be talking to the senior independent director. And then, of course, the role of non-executive directors, fleshed out. And then look here, if you look at section 3, composition, succession, and evaluation, company law completely silent on all of this. And all of this is essentially to have an effective board, right? And later on, we'll be talking about audit. We can't run away from risk. Risk is essential to everything we say. In fact, as I was coming in, I was just thinking that, as I was thinking about this class, it just occurred to me that risk is such a big thing in the sense that when I look at the matters I have presently that are ongoing, everything has to do with risk. Everything has to do with risk. So in one case, and proceedings have already started, and there's a case against JP Morgan and Chase Manhattan Bank. And if you look at it from the context of JP Morgan and Chase Manhattan, as the management basically set up an escrow account as part of its business, into which it received over $1 billion. And it then relied on certain officials to tell it what to do with the escrow account, which it did. And today it's facing a lawsuit. And now, at this time, I'm thinking about it from my sort of corporate governance teaching perspective. If I were in the board of JP Morgan, one, would this matter even get to the board? Would the directors even know about it? That's the first thing, right? Because when the executives set up the escrow account to receive $1 billion, 1 billion plus by 1.2 billion, did the board get to know? And if the board did not get to know, then maybe we need to, in talking about having an effective board, have processes in place to ensure that things like this get thrown up to the board. And you may say, well, $1 billion is a lot of money to us, but to JP Morgan, it's not a big sum of money. That's what they do for a living, right? So that could be one point. But I think the key thing is to every board, every effective board has to identify the principal risks it runs, right? So if you identify the principal risks you run, then you've got to put in processes in place that would ensure the board has oversight of this. Because if that were the case, And if I was sitting on the board, right, and you guys would know this if you're doing Tennekin's class. Any of you doing Tennekin's classes, right? How many of you are doing Tennekin? Yeah. You always get, if you're doing a syndicated loan agreement or a bond facility, you always ask for foreign counsel, right, to provide an opinion, isn't it? Why do you think they do that? Risk. It's risk management. So in this case, what has happened is a government basically says, so this is a government and its lawful representatives, so the Attorney General of the government, the Minister of Finance, they're trying to settle an oil dispute, and they say, we will, as part of the settlement agreement, transfer $1.2 billion into an escrow account. And the escrow account will be controlled by JP Morgan. And when our counterparty has done what we want them to do in the agreement, the settlement agreement, then JP Morgan, when they know that they've done that, so what they needed to do was to surrender something, then JP Morgan should transfer the 1.2 billion to them, right? Now, so JP Morgan is thinking, I'm dealing with the government, right? I'm dealing with the state, the Attorney General, and the Minister of Finance. But JP Morgan did not ask for independent, for counsel's advice from that jurisdiction, right? And they said everything was fine. Now, and anybody who knows a little bit of constitutional history will know that the reason why you had the American War of Independence, at least one key reason, was because of taxation. No taxation, no representation without taxation. No taxation without representation. You can't tax me if I'm not represented, right? And that means that that idea that before you tax me, I should be represented, means that when you spend money, there should be appropriation. The state cannot spend money without appropriation, right? That's why every year there's a budget, right? And you pass an appropriation bill, which basically allows the state, the government rather, of the state, to spend money. So if 1.something billion is taken out of the treasury of the country, right, and put in an escrow account in New York, and then used to settle a dispute, has there been any appropriation by its parliament? Now, any lawyer worth his salt would ask those questions. But because JP Morgan did not ask for this, today they have a big problem. And where all this is going is that if you have an effective board in place, the effective board would, so we're thinking now, you have an effective board that has, so you have like committees, so there'll be a risk committee, right? And that risk committee would, as part of its job, do what we call horizon planning, right? So 360-degree thinking about your business. What kind of risks do we face, right? So if part of your job is to deal in money, to set up escrow accounts, right, then that itself could lead to legal risk. So what kind of legal risks are we going to be dealing with? Now, obviously, there will be legal risks involved in dealing with sovereign states. And how do we manage that? You do not rely on the assurances of the people in government. You ask for independent legal advice, isn't it? And if you ask for independent legal advice, and independent legal advice coincides with what the government officials are saying, then it's fine. But if all you do is simply take the money without asking for independent legal advice, then you've exposed yourself to risk. Now, a company law student, if this comes up, would be thinking about the duty of care. A corporate governance person would be thinking more about how did we get here in the first place? Right? That's what a corporate governance person would be saying. The corporate governance person would say, what kind of board did we have? Was this an effective board? Was this a board that was effective to monitor management? Do you get the point I'm making? So company law deals with the ex post rules to penalize behavior, right? So here we're talking about the breach of the duty of care and skill in the Companies Act, and we're penalizing them, right, for breach of duty of care and skill. Corporate governance would say, did you have a risk committee in place? Did the risk committee meet often? Did the risk committee identify the principal risks that your business would face? And did the risk committee come up with some risk register and, ways of safeguarding, of dealing with the red flags? Right? Do you see? These are ex ante, not ex post, ex ante measures. And and that's why I described this as an app, right? Remember at the very beginning the analogy about apps and the hardware? Because if you have good corporate governance in your country, you'll have all these apps, right? And then your system would work. If you don't, then everybody just has, penalty rules for breach of the duty of care and skill. And I believe every legal system has that. But not every legal system has the apps. Right? Just the same way, you probably will have a beautiful Android or Apple phone with all your beautiful apps, and somebody will have a poor Nokia with no whatever. To think that Nokia was like the best before, when phones came out, somewhere, when people would say, I'll call you on my mobile, I'd say, I'll Nokia you. So Nokia became a verb, right? Okay. So let's go back to this. So essentially, what I've been talking about is summed up here. So I say here that as far as the board is concerned, as a corporate organ, which was what we dealt with before Reading Week, the focus is how to achieve an effective board. And this is what I've been talking about. And I said this is an ex-ante issue dealt with by soft law in the context of the code. So in this seminar, what we do is advance the discussion by considering how company law, so we're moving from soft law now to the law, defines and treats the board and its members and how company law controls them. Because you see, if you're going to give advice about a company, and and usually when it comes to giving advice, we don't make a distinction between corporate governance and company law. They just say advice, right? Then you've got to know what the law says. And this is my point earlier, that anybody who gives advice on company or purports to give advice on corporate governance, you can't do it without knowing the law. So we need to know what the law says and all that. And then here I then say, so we consider how company law defines and treats the board and its members and how company law controls them. And I say these controls apply ex post. And they're part of what I call the hardware of company law. Okay. Now, and again, I just want to flag up this point. Everything we've been talking about is really centered on that, where I say that that the focus on effectiveness in monitoring and control of management, right? So that's, just bear that in mind. The focus is on effectiveness and the control and monitoring of management. And if you look at the guidance to board effectiveness that I just showed you, you'll see that it says that as part of having an effective board, you've got to know your duties. I mean, that surely must make sense. So here the Code on Corporate Governance, right, through the guidance document, which I just showed you, is saying that to have an effective board, you need to know the law, right? Again, so you see the link that you must know the law. And that's the bit here, that effective directors will understand their duties both collectively and individually. Today, we're going to be talking about those duties. And then if you look at the code, section 3 of the code deals again with board effectiveness. It says the board and its committees should have a combination of skills, experience, and knowledge. All right? So again, company law is silent on this. Now, but if JP Morgan, it would be interesting to look at JP Morgan's board, because, you know, I find it strange that this could happen. You see, because it's simply a basic check that, if you're going to pay, if you're going to receive 1 billion plus, you just need to ask foreign counsel. And I'm sure, that's why you do it in your finance courses. And that just makes me, I kind of wonder, what kind of combination of skills do they have on the board? Right? What kind of combination of skills and all that? And so that's one case. And yes, please, thank you for the question.
I have a question. You're saying that the company code is silent on the skill, but what about provision 147? Because it says about knowledge, skill, and experience of each member. So I don't think it's totally silent about it. Maybe not about the mix of the persons that should be there, but to say every person has to have a certain amount of skill.
No. I don't have a problem with I have a problem with JP Morgan's board, not with theirs. Am I missing you? I'm saying that company law, right? Okay, I think I see where you're coming from. Company law basically defines, company law is not hot on diversity. Company law is hot on care, on skills, on knowledge, right? That's what company law talks about. And even then, when company law talks about skills, knowledge, experience, it's coming up with an objective test. It's saying the reasonable man, right? Right? So we'll expect the reasonable man to act with care. So a reasonable man will not sign blank checks, right? Because you will not sign a blank check. I know we don't use checkbooks these days, but it just tells you you're getting old. But anyway, there was a case called Dorchester Finance and Stebbins, where the director signed blank checks, right, for his co-director. And so he was sued. And the director says, the law, so this was before the present formulation, then the standard of care was subjective. And the guy says, I was just being subjectively, reasonable, I didn't have a problem with this. And the court said, even by subjective terms, we'll expect you not to sign a blank check if you're conducting your own affairs, right? Okay. So today, the duty of care, right, is objective, right? So even if you say, I'm careless, whatever, we don't care. It's objective, right? In addition to that, we expect you to have a reasonable level of skills, to be skillful. Again, it's not subjective, it's objective. We'll expect you to have some knowledge. So back in the day, some people would never attend board meetings, and then when they're sued, they'll say, well, I didn't have the knowledge. I didn't, you plead in aid, your own incompetence, your own lack of knowledge. And guess what? They were never found liable because they didn't have the knowledge. Right? So now we apply an objective test to that, right? But my point is this. Corporate governance, in talking about diversity, diversity, unless you tell me that company law talks about diversity, company law doesn't, apart from the new rule, which talks about having women on the board, right, reported, right, so to that extent, that's the first time we're now talking about diversity. But company law has generally been silent on diversity. And we all know that when you don't have a diverse group, then there is groupthink. Everybody thinks the same way. This is everybody, anyone who has a smattering knowledge of research in psychology knows this. You know, it's pretty obvious that if you just have people of the same type together, you know, they just see things the same way. Right? So my point in regard to JP Morgan's board is that, I mean, I don't know how the board was configured. I don't know. I mean, but I just feel that there is a problem if you know, a company takes over 1 billion, right? Because if you think about it, how much were they going to make on the depository agreement, right? How much money are you going to make just to keep money and release? It's not worth the risk. Because if they're going to be sued, they're going to be sued for accessory liability, right? So if they, in a sense, misapply state funds because of a breach of trust by public officers, then we will be asking JP Morgan to repay everything. Now, if I'm on the board, so let's imagine I'm on the board, and maybe JP Morgan likes finances, right? So it's only people who go to Wharton Business School who get to the board and all that. They're not thinking legally, right? But if you put me on the board, the first question I'll ask is, guys, how much are we going to make on this deal? And they say, okay, maybe $1 million. Maybe, in fact, not even up to $1 million. So $1 million, and we're going to be exposed to this level of risk. Why are we doing this? Okay, how do we control it? How do we hedge? Have you asked foreign counsel for this, for an opinion? And that's all you need to do. And once you ask foreign counsel, then you've got your back covered. That's the point I'm making. Right? So the JP Morgan example I'm giving, it doesn't deal with the diversity question, unless, of course, you define the board as just, maybe you put Reverend Fathers on your board, right? So maybe Reverend, well, who knows? Maybe Reverend Fathers actually understand risk better because they receive confessions, right? So they know the deeds of man, right? They know what people get up to. I mean, the mafia, they go for confession and then they go and do a hit, right? So who knows? I don't know. Yeah.
So when you say that both should have a combination of skill experience, you mean from a general point of view? Because I'm thinking about the board of a multinational company where there is also the HR legal director, that he has no knowledge about something specific about the business, for example. In that case, the skills that the HR director should have is general skills, general experience, a general knowledge. For example, JP Morgan, the board should be also the HR director, and he doesn't know anything in reference to financing, debt restructuring, or something like that, but he's going to approve that transaction. So in that case, he has or not the skills, experience, and knowledge?
Yeah. So in fact, that's a very good question, because in that kind of example, in the example you gave, the HR director won't even be on the board. He won't be on the board because, you know, the movement of corporate governance is to have more independence on the board, right? So, and how do you get independence? You bring in people from outside, non-executive directors. So the guys in the company, you make sure they're not on the board, right? So in fact, with the AIG one, the AIG problem, remember we talked about AIG, that was part of the problem. You know, I think they only had one or two people from inside, the CEO and maybe one other person. Every other person was from outside, you know, Nobel Prize winners, SEC former commissioners, you know, the high and mighty. But they could not spot a red flag. Right? And the red flag in this case was the requirement to post margin. You know, when you do your credit default swaps, if you start facing requirements to post margin, to put in more money, then it's a kind of red flag. And so they were not aware of this. So I suppose in the JP Morgan case, yes, those skills you're talking about will be at the level of management, right? But at the board, it'll be different. So the question would then be, how is the board constituted? What kind of committees do you have? Because I think that's, you see, you can't deal with everything at the level of the board just like that. You need to have committees. So let's imagine JP Morgan had a risk committee then presumably you would have a lawyer, somebody with a legal background, right? And a legal background that is sensitive to risk on that committee. You would also have, people who sort of, ideally, I would like somebody with a sort of compliance type background. Do you understand? There. Then, it's not enough to just have a committee. You also have to have a system to identify risks. So there must have been a system on the board to identify the principal risks the business faces. One way you do this is to have what we call a risk register. So the board sits down and says, let's think the impossible. Let's think everything. Like Donald Rumsfeld said, the unknowns, the unknown unknowns, right? Which by definition means you can't even think about those things, Let's think about all the black swans, everything, right? And you see them all scratching their heads and thinking about everything. But, I mean, with JP Morgan, you really don't need to be a rocket scientist to know this, that if we're going to be doing this kind of business, we're going to be receiving money. And where would the money come from? It will come from $1 billion. It's going to come from sovereigns or big companies, right? And we just need to have some processes in place, right? So that's the point I'm making, right? And so for me, this is a very obvious one. So this is one of the cases I was saying that we've just filed the case. It's now in court. Then another one I'm working on, which we've just issued. We issued the letter before action 2 days ago, and that's against an Italian company called ENI, E-N-I. And I can see, are you Italian? Oh, okay. Yeah, okay. So, and here we're talking about, people at a high level in the company basically taking bribes, right? Taking bribes. And this is exposing the company to a liability, again, to the tune of over $1 billion. And the question is, how do we then control this? Right? So, and that's why I say, let me just see if I can get, I've sort of redacted some of the stuff. So this is a letter. What makes these cases really interesting is when you read the transcripts of the telephone tapping. It's just really interesting. So here, these are the guys. And in fact, one of the guys involved used to be a magistrate. Right? So let me just see. I'm trying to, okay. And by the way, these are the codes for people. A good guy, Fortunato, the lady. let me. Man, like crazy, some French. You've got to be really careful. The French are. Sorry, anyway, I better stop. So, but essentially, here you have directors of a company, right? Directors of a company pursuing a deal for the company, right? So they're pursuing a deal for the company. So that's good, but they also have a collateral interest for themselves. So if they get this deal for the company, they also get a few $1 million in their private bank accounts, right? And and these then go to these offshore havens, which were recently attacked. So in a sense, on the face of it, they're saying we're working hard for the company. We're trying to promote this deal, right? And in promoting the deal, if they get it, they also get a bribe. Do you see? But if it comes out, so if it doesn't come out, actually the company benefits. The company gets the contract. If it comes out, the company loses, right? Because the company has to pay fines, disgorge, and the company basically loses. So the question then is, what systems should a board have in place, right? How do you have an effective system in place to prevent this from happening? Isn't it? Right? That's the real question. Right? Now, and I mean, as I was saying, as I was walking down, and in fact, when the fire alarm came, that's when I decided to just put this up, and I quickly did some quick redactions because I just saw the link. Because the third case, which I've mentioned before, remember the Muddy Waters case, which deals with the Mexican authorities. So again, that deals with risk, right? Remember, just to remind you, so in that case, the OSI and Rapid Scan have been shorted, right? They've been shorted by Muddy Waters. Muddy Waters is a hedge fund that basically shorts companies that they think are either overvalued or have big corruption problems. And having shorted them, they've provoked a DOJ, a Department of Justice investigation, right, so that the share price will fall. So Muddy Waters is panicking, and Muddy Waters has a contract, a $26 million contract with another company, and they now want to pull out of that company. And so this is where, so I come in to provide advice for the board of OSI. So, and when I write my opinion, so it's like a 22-page opinion, and the idea basically is I'm trying to speak the language that I think the compliance guy will understand. I'm trying to speak the language I think the risk management committee will understand and the board will understand. So basically the way I structure it to say, guys, I'm on your side. I know what these things are about and your responsibilities, but I think you're a bit being you're being too careful, you're being too risk averse here because there's no problem with the contract. And how you then do it is show that legally there's no problem with the contract, right? So they've ticked all boxes. And secondly, the contract passes the smell test, right? It doesn't smell. So it's not enough to say the contract is legally fine, right? Because then you don't answer their queries. You've got to show that the contract does not fail any smell test. Sorry?
How about test? I think it has 3 points. It smells, test, and it feels like one. Yeah?
How does it feel like one? So this is an amplified smell test.
Yeah.
Well, first of all, it's not in my interest to discover such a test. I don't think there is a test. But if there is, the client is not paying me to identify that. In fact, I thought that the board is thinking about it legally, right? The board is simply thinking about it legally, that this contract that we're entering into. And I'll tell you, the issues here is that one big issue is that the buyer is paying up front. That's the big issue. That the buyer, so we're talking about a contract for scanning equipment. I mean, not your scanning for paper, but stuff going into passing borders, like containers. And the question is, why is the buyer paying up front? Right? That's the red flag. So how do you answer that? First of all, you show that legally there's no law that prevents the buyer from paying up front. Right? That's the legal answer. Right? But that's not enough. Because, why is he paying? Do you see? So you tick the legal box, but you don't tick the smell test box. So I say, from a public procurement law, most states have public procurement laws, there is no law preventing, the company or whatever, or the state from paying upfront, right? If you do things properly, which they did. And then secondly, to deal with why they paid upfront, the smell test, I said to OSI, are you giving the buyer any credit? Clearly not, you're not. So you're not giving the buyer credit, and you're expecting the buyer to basically pay you $26 million, right? without any credit from you, and then not be paid by the end user. And the end user, by the way, has bad credit. So I said, the fact that this contract requires payment upfront, right, actually is proof that everything is fine. If they didn't ask for payment upfront, then that would be an indicator that there is a problem with it. Do you see? It is because the contract is so clean that they're not getting any credit from you, and these guys generally have bad credit. They're saying to these guys, before we do this, you pay us the money up front, and then we will give OSI the money and get the equipment. So do you see how you can then switch it? So the payment up front becomes a badge of good contracting, not an indicator of something wrong. Right? So these three cases which I've just mentioned, they all deal with the question of risk. Do you see? They all deal with the question of risk. Obviously, the first two deal with us coming to attacking the board, and the third one deals with me being on the side of the company. But the point I'm trying to make is that we need to focus on what an effective board is, right? Because an effective board is one that is able to ask and address these questions. Okay. Now, so here I say it is not enough to have a monitoring board. It is also important to have a board composed of a diverse range of perspectives with industry know-how. And here I refer to the AIG case. Okay, then, so against this background, so please read the code, right, because you see me making links with the code. So if you look at section 3 of the code, it talks about the appointment process to the board, right, which company law is silent on. I know somebody was talking about company law, but that's another example where company law is silent on the appointment to the board evaluation. In fact, when you sit on a board now, what you tend to do is you identify risks. So you sort of get a chart which goes on, a chart which is sent around where everybody sort of puts their core competencies. So the idea basically is to identify gaps, right? So you identify gaps, and then you then say, okay, let's fill those gaps, right? I sit on the board of an ISLP, which is it deals with we provide pro bono legal advice around the world. It's called the International Senior Lawyers Project, based in the United States, New York, and London. And so I'm a trustee and director of ISLP. And recently we went through this exercise, right? So we basically go through everybody's skill set, we look for the gaps, and then you then go out to recruit somebody who can fill that in. Again, company law is silent on this. So what are the objectives of this seminar? Which obviously will start in earnest when next we meet, because remember I said I'm going to shadow. So maybe the fire alarm was a blessing in disguise. So essentially, with the background we've already talked about, we're going to look at how the control of the board, the control of management is mandated by company law through the board. And so we start with 5 objectives. So the first is the role of the board and how the law deals with a problem, which was first identified by that Roman poet, who guards the gods. And then the second one is the rationale for the imposition of fiduciary duties. Notice, we always talk about fiduciary duties when we talk about directors. But how do fiduciary duties sneak into the picture? Because, you know, the company is a creature of contract, certainly in the context of Section 33. Remember we talked about Section 33 the other time. That the contract at the heart of the company, right? The juridical relationship at the heart of the company is contract. So Section 33 of the Companies Act says that the members, right, are bound in terse with the company. So contract is at the heart. Now guess what? If you have a contract, do we ever talk about fiduciary duties? If I want to sell a car to you, and so that's contract, right? And there's a problem. Do I sue you, or do you sue me for breach of fiduciary duties? Because that's a purely contractual setting. How does fiduciary duties come in? You understand the point I'm making? If you go to the market, go to a supermarket, you buy a car, whatever, it's contract. So the question we need to ask is, how come fiduciary language sneaks into the corporate picture? Why do we use it? Sorry?
I think the contract in the company is the constituent article of the constitutions. Is the contracts between the shareholders.
Yeah, and the shareholders and the company.
But the fiduciary duty is a duty between the shareholders and the directors. It's a different thing.
Oh, okay. Good point. So you're saying there is a fiduciary relationship between
the shareholders
and the directors. But the shareholders are not part of the picture. The directors owe their duties to the company, not to the shareholders. Remember, separate legal personality. Shareholders are not part of the picture because of depersonalization, right? So the corporate form, separate legal personality, becomes the person. The person, the company, owns property. If the company's property is lost, who sues? The company, isn't it? If the directors burn down the company's property, right? Who sues? The shareholders or the company? The company. So why did you bring the shareholders in? So you see, when I spotted it, I thought, okay, let me get it. Okay, but can you refine your analysis now that we've removed because I think, or do you think everything comes crumbling down, or do you think we can salvage it? If we just remove the company, just remove the shareholders. Remember, the question again, just to repeat it, is in a purely contractual setting, right? So the company, obviously, statutes tells us that the registrar of companies, by registration, creates the company, isn't it? Right? So you form a company through registration. But then the relationship at the heart of the company, what brings everything together, is contractual, the Section 33 contract. Okay? And I'm saying that if there is a Section 33 contract, then it's all contractual, then why don't we apply normal rules of contract there? And I give you an example of, if I go to the marketplace and I buy things, we never talk about fiduciary duties. We talk about, a breach of the contract, right? And if I mislead them, or if there's a tortious liability somewhere, or grounds for tortious claim, then they sue me in tort. So the question is, if you're not suing in contract, you're not suing in tort, how come you're bringing in fiduciary principles? That's really the question. Okay, so exactly. So your point is that the director the director is in a relationship, obviously not with the shareholders. The director himself is not even a party to the Section 33 contract. If you look at Section 33, it does not mention the director. Yeah. But the director has been appointed, isn't it? So when he's appointed, I suppose you could do it in two ways. You could say to the director, make many promises to me. And you would begin to write the promises, and it will never end. Don't give that contract to your girlfriend or your boyfriend. Don't do this. Don't do that. Work well. Don't sleep on the job. And all that, right? Don't make a secret profit and all that. The contract will never end, because we don't have unlimited foresight. We have the problem of what they call bounded rationality. We just can't. And the transaction cost of writing that contract will be immense. So I suppose the thing we could do, right, is okay, we have a contract of employment and say this is your duties. And then we turn to fiduciary law, right? So fiduciary law does not need to have all those stipulations, right? Just the same way we don't need to have pat-down searches of people when you go into a bank to say, we're going to search everybody when you go into a bank, don't take in a gun or don't do this or don't steal money, whatever. But if you do something wrong, then there are penalties. So the fiduciary principle comes in to say that because we give you enormous discretion, do you see that's the problem? We've given directors enormous discretion. And what's the discretion? We say to them, you manage the company, right? Remember? The directors of a company are given managerial powers to manage the company. And if you have the power to manage, it means you have the power to do many things, right? So the best way to control somebody with enormous managerial power is to use fiduciary law. That way, we don't have to have a long list of contractual terms. We simply say, if you make a secret profit, you have to disgorge. If you don't, if you're not loyal, if you don't act in good faith. Do you get the point? You see, if I deal with you, if I go and buy a car from you or whatever, it's a discrete transaction. I don't need fiduciary law. I can protect myself with contract, right? With the express terms of my contract, right? And Parliament helps us with implied terms, right? So the car should be of satisfactory quality, right? And all that. So even if I didn't write it down and you told me you're going to sell me a very nice car and, and the engine is not working, right? We'll say, well, the car is not of satisfactory quality, right? But it's in contract. But with fiduciary law, or rather, with a contract with somebody who you give enormous discretion, when you say somebody is your fiduciary, you're basically saying you've given this person a lot of power. There used to be a program, I can't remember, it was some law program. This was way before Sex and the City. And the lawyer was making a speech. I can't remember the name of the program now, but it used to be, now they talk about suits, right? This was before suits, right? No, it wasn't. Was it? Yeah, maybe. Yeah. That's it. Yeah. And so yes, that's it. Yeah. And so this lawyer is making a speech in a church at a wedding, and he's talking about somebody, and he says, I think she or he is my fiduciary. And it was so beautiful, so poignant. What the person is saying is, I rely on this person, I trust this person. And that's really what it is. When you rely on somebody, when you trust somebody, when you give, literally, it's a power relationship. When you have a power relationship, then the common law, and when I say the common law, I'm using the term loosely, because actually it's from equity, right? Equity steps in to say, we will protect you, right? We will ask this person to act with good conscience, right? So these doctrines came from the equitable part of our law, and hence the use of ecclesiastic language like good conscience and such like. So that's it, the rationale for imposition of fiduciary duties. And just to quickly show you what I mean on this. Now, so if we look here at Lord Selborne, he doesn't tell us why, right? He just tells us, he gives us a standard legal answer. So at this point, we're not really thinking, right? Just sort of follow his analysis, but there's no real thought in there. He's saying the directors are the mere trustees or agents of the company's, trustees of the company's money and property, agents in transactions they enter into. And because trustees and agents are regarded as fiduciaries, then we say, okay, they're fiduciaries. But that doesn't tell me anything. It doesn't. You know what? It doesn't tell me anything. Because, and you'll see why in a minute. And then, but the standard answer, right, proceeding from 1872 is that these guys are fiduciaries, right? And we kind of proceed on that basis. And I think it's kind of misleading. Because we can design the fiduciary duty away. You know, we could appoint a director and say, we're appointing you because the law says a company needs a director. But you will not have any powers of management. So we could actually have a board and not give the board powers of management. So you remember that part in the model articles which says that the duty to manage the company shall be vested in the board of directors. We take it away, we write it away and cancel it. So all we just have are directors. So the directors, they are directors legally, but they have no power. That's what I've just done. I've removed the power. There's no power relationship. So the question then is, are those directors fiduciaries? Now, if you don't know if you don't really understand the thinking behind it, you would say, well, they are fiduciaries because they are directors. I would say, no. They are directors, but they are not fiduciaries. Right? That's what I would say. And look at what Lord Justice Millett says in this case. Right? He says the expression, it says the expression fiduciary duty is properly confined to those duties which are peculiar to fiduciaries, and the breach of which attracts legal consequences differing from those consequent upon the breach of other duties. Unless the expression is so limited, it is lacking in practical utility. In this sense, it is obvious that not every breach of duty by a fiduciary is a breach of fiduciary duty. So, two things here. A, we need to identify who is a fiduciary, right? And then even after identifying a fiduciary, we then have to ask, has the breach of duty by this fiduciary, does it amount to a breach of fiduciary duty? You get it? Two separate questions. Who is a fiduciary? And that's what we're talking about. And the second question is, even if we conclude that somebody is a fiduciary, does it follow that every breach of duty by this fiduciary is a breach of fiduciary duty? That's the second question. So let's stick with the first question. Who is a fiduciary? Here he says, he doesn't tell us who the fiduciary is. Notice he doesn't. He assumes we know. Right? And I say that a director is not necessarily a fiduciary. Right? Most times, a director is a fiduciary, but it's possible to design things in such a way that the director has no powers. And if he has no powers, then he's not a fiduciary. Now, if you look at the Pilmer case, in case you have any doubts, look at this. It is important to recognize the distinct character of fiduciary obligation, which sets it apart from contract and tort. the foundation and ambit of the fiduciary obligation are conceptually distinct. Right? And he says that in negligence and contract, the parties are taken to be independent and equal actors, concerned primarily with their own self-interest. That's why when I enter into a contract with you, I don't need fiduciary law. Consequently, the law seeks a balance between enforcing obligations by awarding compensation when those things are breached. The essence of a fiduciary relationship, by contrast, is that one party exercises power on behalf of another and pledges himself or herself to act in the best interest of the other. That's Ali McBee, right? Isn't it? That's it. That's what the guy was saying. Yes, he was talking about his girlfriend, and he was saying, she is my fiduciary. And I thought that's the highest level of praise, of accolade, that you could possibly use for your partner. I just hope your partner has some legal training to appreciate the enormity of the praise. Otherwise, it will just fly over. Right? So that's it. So if we take this, if we take the Pilmer case, and we sort of fix our minds on that, we then come to the company context. So before we say a guy is a fiduciary, even if it's a director, we look at the articles. How have the articles confided power? Now, in 99.9% of the cases, the directors will be given those powers, isn't it? But not in all. Not in all. Now, if the directors are given those powers, right, then this basically applies. Then what Lord Selborne basically says will be the case. The directors will be trustees in regard to property. They'll be agents of the company, right? Then we come to the second question, right? Remember, the second question is, does it follow that because we say you are a fiduciary, every breach of duty by a fiduciary is a breach of fiduciary duty? And I say no. And let me put it this way. Take a trustee. A trustee is a quintessential fiduciary. If a trustee loyally does his incompetent best, can we say he's guilty of disloyalty or negligence? What is he guilty of? Disloyalty or negligence? You loyally do your incompetent best. In other words, if you do that, have you breached a fiduciary duty? No, you haven't. You haven't. Because a breach of a fiduciary duty, is about disloyalty. And these are not mere words. They have practical significance. I was just advising, I did an opinion last week on something similar, and it just occurred to me as I was speaking. And I'll show you the practical significance. It's on limitation. So here it's about a case which is being planned and against somebody or some companies for accessory liability. And the problem is that the limitation period is set in, right? We're talking about like 10 years. And I say, this case is not going to fly because of the limitation period. The way around it is to say that the defendants are fiduciaries, right? Or at least they're accessories to a breach of fiduciary duty, right? And the reason why I need to say they're fiduciaries is because if you say they're fiduciaries, they're trustees, then the limitation period does not fly, does not work, right? So, in a pure, think about it. If a trustee steals trust funds, you're a little child, your father gives a trustee money to keep for you, and the trustee steals all your money, right? And then you then grow up and you now realize and 20 years later you sue the trustee, and trustee says, oh well, there's a limitation period. The courts are going to say, no, there's no limitation period where the trustee is concerned. You get it? So there is a practical advantage to describing a breach as a breach of fiduciary duty, because it means you jump over limitation hurdles. So if I'm dealing with a director, I suppose if I'm representing a director, let's put it this way, if I'm representing a director, and somebody says the director, was negligent, he's a fiduciary, right? So Mr. A is a director, B, Mr. Director, or Mr. A, who is a director, has been negligent, and therefore he's breached his fiduciary duty. Assuming they run the argument that way, I would say, well, even if he's a fiduciary, and even if he breached his duty, right, in regard to negligence, that is a breach of the duty of care, not a breach of a fiduciary duty. Do you see? I will confine it to a breach of the duty of care and not a fiduciary duty, because I know that if it's a breach of fiduciary duty, then there's no limitation, period. Right? So this is why, look at what Millett is saying here. He says, it is obvious not every breach of duty by a fiduciary is a breach of fiduciary duty. Right? That's really what he's saying. Right? And also we see this in the judgment of Soughton J. in Gerardet, where she says that the word fiduciary is flung around now as if it applied to all breaches of duty by solicitors, directors of companies, and so forth. So what we're seeing here is that the duties of directors are not all fiduciaries, right? So if there's a breach, don't quickly say because the director is a fiduciary, it must therefore be a breach of fiduciary duty, because the consequences are different. Now, and remember, all we've just been doing is just flagging up the objectives, right? And I was just saying, why do we impose fiduciary duties, right? And then the third objective is, and my apologies to you, because your answer was before this third objective, right? You're kind of ahead of us. The third objective, to whom are the duties owed? And obviously I hadn't taught you that the duties are owed to the company, right? And that's why you give that answer. So we're going to be dealing with to whom the duties are owed and whose interests are to be considered. And then number 4, we'll look at the core fiduciary duty of directors. And then number 5 is really important. The state of the law regarding the duty of care of directors, right? Because this is going to be very important. What are the factors we need to sort of look at, right? So those are going to be our objectives. And I just want to say, as a prelude to what we're going to be talking about, and it is this. So in this case, so this is where I'm going to stop. In this case, in U.S. and Chenery, U.S. SEC and Chenery, you see Justice Frankfurter, who said that to say that a man is a fiduciary is merely the beginning of analysis. Right? It gives direction to further inquiry. To whom is he a fiduciary? And that's going to be the question we're going to be asking. Okay, right? So, but we're going to broaden the question somewhat by saying, to whom does he owe his duties? Because we now know that there's the duty, there are fiduciary duties, and the duty of care. Right? So now we're talking about standard cases, right? In 99.9% of cases where you have standard articles, right? There'll be fiduciary duties and the duty of care. Obviously, in that tiny case where there are no powers at all, then we don't have fiduciary duties, right? But we're not going to bother with that. We'll just put it there for analytical reasons. So to whom does he owe fiduciary duties? Or to whom does he owe duties? In what respects has he breached his duties? How has he deviated? What are the consequences Right? You know, that framework is what we're going to use to guide our thinking as we go through this, so that whenever we're confronted with a sort of corporate governance problem, we're going to start by thinking, okay, where am I coming in here? I mean, am I coming in from a sort of a reform type, perspective, where I should be focusing on ex ante issues, how to have a good board, an effective board, or am I coming in at the point of liability, right, ex post? And if it's that, then I need to consider, what duties do the directors owe? What are the consequences of a breach of duty, the remedial consequences, right, down to accessory liability, right, because that is the consequential issues. And that's essentially what we will be talking about. So we will continue, right, because we're going to have our normal 2-hour class, and I'm just going to schedule an additional class. So that takes care, right? So in a sense, the fire alarm worked. I hope we don't have fire alarms every week, so we will effectively double my work. But anyway, thanks, and good to see you again. So that we don't get locked. I'll wait for you. Okay.
For the tutorial.
Okay.
And so my second tutorial is tonight.
Okay.
But I wanted to know if I could go to the one next week because I have an appointment with a dermatologist.
So I'm not the person to ask.
Yeah, because I didn't find the email.
So
yeah, I didn't find his email.
Okay.
Yeah.
I think the best thing to do is if you just send a quick email to me now.
I did yesterday. Should I?
Okay, don't send it to the King's account because I very rarely get the chance to check it. So if you can just send it to nora.leadazon@SAS, if you send it to that email address instead, and then I'll forward that on to the tutor and see if he can get back to you about.
I'm just gonna write your address down.
Yeah, good idea. Got a pencil, paper. I'll just give you a card if I have one. Let's see. Here we go.